effective interaction and communication with the law enforcement personnel. And oftentimes we're just not sure what it's okay to do and what it isn't okay to do. So today I'd like to introduce AnnMarie Wilson. She's Juris Doctor from the UC San Diego Office of Risk Management, is graciously here today to talk about this interaction and communication that we have with the law enforcement. Please join me in welcoming AnnMarie.
Thank you, everybody, for having me here. I want to let you know, first off, that nothing is black and white here, okay? There are going to be instances where you're not going to know for sure. You're going to be unclear about what's the law, what you can do, what you can't do, what the police can or can't do. And in those instances, I'm probably going to repeat several times today, talk to your supervisor or call risk management. I had some questions emailed to me, questions that apparently come up quite often in trauma, so we will try to answer those as best we can. But initially, I want to start out in general, and I'm sure you probably already know this. Nurses and other personnel should not perform medical evaluations or procedures requested by law enforcement except the patient consents, a medical emergency exists and the patient does not object to the procedure, an officer requests blood test pursuant to Vehicle Code 23612. That is the implied consent law. And if you're not sure what that is, we'll get to that in a few minutes. And the patient does not forcibly resist. I don't care what the law is. If the patient forcibly resists, you don't do it. If the officer requests non-invasive medical evaluation to determine if it's medically safe to incarcerate the patient, then you're allowed to do that if the patient does not forcibly resist. If the officer requests a medical evaluation or procedure pursuant to authority to conduct constitutionally permissible search, then you're allowed to do it. And here's where we will get into gray areas. If the officer requests a medical evaluation or procedure pursuant to a valid court order, then of course you do it, unless the patient forcibly resists. We don't want you hurt. And if the request involves the collection and release of evidence of rape or other sexual assault from the alleged victim, then yes, do it. But again, if the victim resists and doesn't want any blood samples, clothing, whatever collected, don't do it, no matter how much the police push. Call your supervisor, call risk management, call security, whoever. Now, I've had some questions before about, well, what does HIPAA say? And of course, we all know HIPAA is about patient privacy. We don't give out information unless certain rules are followed. But we cannot always rely on HIPAA. Quite often, California law is more strict than HIPAA. And sometimes our own policies and procedures are more strict than HIPAA. So California hospitals may only disclose information if it's allowed both by HIPAA and California law. And as I said, California law is often less permissive than HIPAA in disclosing information. So what do we have for permissible release of information? If there is no search warrant or subpoena, you are allowed to disclose name, address, age, sex, the general nature of the injury, and any other non-medical information. But you will notice that we do not give out the Social Security number. HIPAA allows that. HIPAA allows several other things as well, but California does not. If police, prosecutors, whoever try to push for that information, no. Permissible release of information where there's a victim of a crime, only if the patient agrees. If the provider is unable to obtain an agreement due to incapacity or emergency circumstances, then you can release information provided that the officer represents the information is needed to determine if a violation has occurred and will not be used against the victim. If waiting until the victim is able to agree will adversely affect the investigation, and the disclosure is in the best interest of the victim. Now, how do we determine if what the officer is representing is the truth? Use your best judgment. And know that if you have been fibbed to and you've released something that should not have been released, you will not be liable for that. Okay? You are protected, not just by the UC system, but by the law. Release of clothing and property. If the patient is in custody and they say yes, if they violently disagree, then don't release it. Let the cops take care of that. But if the patient is in custody, then yes, you can release the custody or the clothing or the property. Of course, if there's a warrant or a subpoena for the property, then yes, release it. If the patient is a victim, yes, release the clothing or property, subject to the points on the previous slide. If the victim objects to releasing anything, then we're not releasing it. I don't care what the police or the prosecutor's office says. Blood draws, and this is going to, I had to ask a question out in the hallway to find out for sure what someone meant by asking if nurses are responsible for DNA sampling. I thought I knew what that meant, but the question was answered for me, and I presume that means, you let me know if I'm correct, swabs? Is that right? If somebody asks you to do a DNA sampling, I presume they're talking about swabbing. Now here's another question for you. Do the police bring in techs to take blood or to do swabs? They do? Okay. Do they ask you on occasion to do it? Pardon me? Blood, not swabs. Okay. The blood draws or the DNA sampling, if you are asked to do it, there's only two legal bases for you to do it. And that is under the vehicle code, the implied consent statute, which means if you are driving a vehicle, you have given consent to have your blood drawn. The other legal basis is the officer's right to conduct a reasonable search. So as I said, California states that a person who drives a motor vehicle is deemed to have given consent, actually not just to a blood draw, but to any chemical testing. But it must be incidental to a lawful arrest, and we're going to have a caveat to that in a minute. And it also applies to minors. No parental consent is necessary to test a minor if they were driving that vehicle. Now, incidental to arrest. 2 California appellate courts have ruled that an arrest is not required prior to the blood test as long as there is probable cause to believe that evidence of a crime will be found and the withdrawal is accomplished in a medically approved manner and without unreasonable force. So, If you tell a cop, okay, wait a minute, is this, or if you ask the cop, is this incident to a lawful arrest, and they say they have probable cause, don't argue with them, okay? The other thing I want to ask you, do they give you forms? Do they fill out forms for you before they draw blood or ask you to draw blood? They don't? A request for a blood draw must be in writing. Yes. Any blood test request by a peace officer must be in writing. And the California Hospital Association has a form. They prefer that form be used. Now, some of the law enforcement agencies have their own forms. CHP has a form, but it does not include all the pertinent information that's required under HIPAA. So if the officer uses their own form, we should be requiring that that CHA form be filled out as well. No blood draw if no acceptable written request. And the written request must go in the chart. I take it we don't have any policy or procedure that states that we need a written request. Is that true?
I don't know.
And I haven't found one. But then, what I can look up on the intranet is not always everything that exists. There are things that exist in binders on floors, and, some things just have to be hunted down. If you don't know anything about a written request for a blood draw, then I'm going to presume there probably is not a policy. And I'm going to talk to some people after today and ask that we put policy in place, okay? And we'll probably ask that some of you help out with making that policy. Interrogation during a resuscitation phase. I got an emailed question regarding that. And what was there? Let me see. Are medical personnel required to allow police to interrogate a patient during the resuscitative phase prior to completion of procedures and/or definitive diagnosis? You know what? I'm just going to say no. I mean, you're trying to resuscitate a patient, correct? Are the police in the way? Give me a scenario of what you're talking about when that question gets answered. Anybody, give me a scenario.
The patient gets stabbed and the police are wanting information so they can go find the person that did it.
The patient has been stabbed or shot or whatever, and the police are there wanting information. You're trying to resuscitate, correct?
They're in the primary phase of the doctor trying to do their evaluation. Primary and secondary. They're sometimes in there at primary and step away, and they come back during secondary when you're trying to get your radiological studies, things like that. And you're stepping in and out, asking questions.
Okay.
But that's usually with our consent. I've never had them do it even if we said, wait, you know what I mean?
Okay, so the patient is in a primary resuscitative procedure and the police are asking questions, whether it's a victim, whether it's a suspect, and the doctor's trying to get things done. The nurses are trying to get things done, and maybe the police are in the way a little bit. So if you ask them to leave and they do, then they just come back during the second phase, correct? And if you ask them to leave, they generally do? Okay, you've never had an instance where they push and they don't want to leave? Are there times when you would prefer that they leave? Was that a big fat yes? If you would prefer that they leave, ask them to leave. If it's medically inappropriate for them to be there, ask them to leave. They have no right to be there. Even if they say incident to lawful arrest, even if they say we're afraid we'll lose information, if it's not medically appropriate for them to be there, if they're in the way, then they shouldn't be there. Your primary focus is a patient, not a victim and not a suspect. And certainly if the patient is not consenting, they have to leave. I know that we have a delicate balance between ourselves and the police department, between ourselves and the prosecutor's office. And it's not just in trauma, it's in the ED, it's with risk management, it's on the floors, it's everywhere in the hospital. They do get in the way, and they do ask for more than they are allowed to have, and they're counting on us not knowing that they are not allowed to have it. But we also want to cooperate as best we can, to the extent that it's legal for us to cooperate. So there is a delicate balance, and there are many shades of gray, and none of this is ever going to be black and white. To me, the only black and white issue is that person is a patient, and the patient comes first. If in doubt about anything, your supervisor, call risk management, make the police wait while you make a phone call. We've had instances where, I didn't put this on a slide, but we've had instances where the police have asked, call us and let us know when you're discharging the patient. Yeah, okay, you know what? If they're not under arrest, no. No. Because you will end up having to give information that is medical information, and that's a violation of HIPAA. Now, if you can think of some way to let them know the patient is being discharged without violating HIPAA, I'd like to hear it. But we have had this on the floors several times. And then after we tell them no, they'll say, well, but we have a warrant for their arrest. Well then, okay, hang out outside, watch for them to come out and arrest them, or come in here and arrest them. But if they're not under arrest, they are strictly a patient, and we would not call the police to let them know any other patient was being discharged. We had a situation, just that situation happen, where the police called and asked, hey, don't let him leave. He's ready to be discharged, and he has not been arrested. But the prosecutor's office called and said, don't let him leave until we get somebody there to question him. And this was a prosecutor from Imperial County. So they expected us to keep the patient in the bed for 2.5 hours until somebody could get there to question him. Now the patient ended up being there for another 3 hours, and the investigator from the prosecutor's office was able to get here and question. But of course, when the defense attorney found out that the prosecutor's office had called and said, please hold him, what do you suppose happened? Then, of course, there was a motion in the Imperial County Court about constitutional issues and whether or not the patient was held involuntarily and was questioned without an attorney. And guess who had to go testify in a motion hearing in Imperial County? A nurse who was scared to death, thought she was in trouble. So she and I went together. If something like that comes up for you, call us. If you get called into a hearing or a deposition regarding any issues that happen in trauma, in ICU, we are more than happy to walk you through it, go with you if you want us to. I know that I have not covered nearly the things that you go through in the trauma bay or in ICU. Do you have any questions? Yes.
If an officer was trying to get a piece of information or a sample, whatever it was, that he had the right to get, and we were resisting, what channels would they go through, or what can they do to show us? Do they have an avenue to make sure they get what they want?
If they're asking for something that they are allowed to have and you're resisting,
or if we think, I'm not allowed to give that to you in the story, but we're wrong.
okay. Ask them, if you're not sure, ask them what grounds they have for asking for it. Tell them that you are unsure. Of course, they're going to try to convince you, but if you're unsure, if it really sounds wrong, then say no and then go check. Let them know that you're going to check with security or risk management or whoever, that you're not just getting in their way. But if you're unsure, don't give it. Not until you check. Yes?
If I would have a question, is this number available 24 hours?
If you were to have a question, no, those numbers are not available 24 hours, but let me give you one. Do you have a pen? My pager number is 2333. And believe me, I have been paged at 1:30 in the morning before. So it wouldn't be the first if somebody here did it. Yes?
I had a patient in the unit who was intubated, and the cop came in, he wanted to do the swab. But we were concerned, he said he had a warrant to do the swab, but the warrant was, it did not official. And so we were just going back and forth and a hard time. And he ended up doing it after the night, but he was doing it at such a hard time. So I don't know legally what that was. The patient was free of it. We don't know what a warrant looks like. Yeah.
Okay. Okay. We're going to get some examples. We're going to make you a binder. Let's make you a binder. We will get examples of some of these things. And even if they have a piece of paper that purports to be a warrant, there are certain things that warrant must contain. And I am going to give you the little bullet points, what that warrant must contain. If it doesn't contain those things, or if you're not sure that it's valid, call us, okay? Or call security, Mike Leach. He is very well aware of what a warrant looks like, okay? Anything else?
So if we went ahead and let them do it, and then the warrant wasn't okay, we're not expected to be a warrant expert. We're not going. If they showed us something and said it was a warrant, it's reasonable that we would believe them. We're not going to get in trouble for that.
No. If they show you something that they say is a warrant, and you rely on that, and it turns out it was not a warrant, no, you will not get in trouble. You acted in good faith, and truthfully, you are immune from liability in a situation like that. Okay? Yes?
Is there ever a situation where we would get in trouble if we're not sure about it and they're asking us to do something we don't feel comfortable? Is there ever a situation where we would get in trouble for not cooperating?
Is there a time when you would get in trouble for not cooperating with the police? I would imagine that the police, if they're really pushy, are going to start using words like obstruction of justice. But if you are not sure, don't do it. If they are really giving you a hard time, call for help. There is nothing wrong with you making sure. They cannot arrest you for that. Okay? They can threaten it, but they can't do it.
Yeah, we frequently get uncooperative hostile patients in New Hampshire, but I'm not talking about when a crime is committed. The patient adamantly refuses to have his clothes cut off, and got to be started, and rectals ran, and this or that, and the medical personnel do the procedures anyway, sometimes even restraining them. Like, what are the legal ramifications of that?
Okay, the question was, when you have a difficult patient, might not be a victim or a suspect or whatever, but the patient doesn't want their clothes cut off, they don't want any procedures done, and we go ahead and we do it anyway. First of all, why do we go ahead and do it anyway? Is the patient so injured that it must be done? It's an emergent situation?
Routine workup for a trauma patient if they meet the criteria for a trauma resuscitation.
A routine workup to see if they meet the okay.
A lot of times too, they use it could be a head injury is why they're acting like this. So
Okay.
Or they're under the influence, so they're not able to make a valid decision on their own.
That's what we
And are
use.
intoxicated patients allowed to make their own decision?
Yeah.
Pardon me?
Are intoxicated patients allowed to make their own
No, they're not competent to make their own decisions.
Does it have to be a certain level?
Yes.
Alcohol?
Yes.
What's the level?
What's the level? For me, the level would be really, really low.
That's their point.
Yeah, but if they're alert and oriented,
And
but intoxicated.
Yeah, if they're
They're alert and oriented and answering all the questions. They
And their level's
refusing.
still a 0.3 or something.
You know, that's a call that the physician has to make. Somebody who, I know people who could be 2 or 3 times over the legal limit and seem perfectly sober, but they're not. They're just very, very good at looking that way. And I would not trust them to make their own decisions. Myself, a half a glass of wine, and no, forget it. I'm not competent to make, well, I could probably make some decisions, but I wouldn't count on them tomorrow. So it's at the physician's discretion. If there is suspicion of a head injury or extreme intoxication or something where the physician believes that we could be in an emergent situation, then yes, I can see overriding the patient's struggles and cutting off the clothes and doing what needs to be done. And even if that patient came back later and tried to sue, neither the physician nor you would be liable, because it was in your best medical judgment to do what was being done. If at some point, blood test comes back and you find out, no, they're really not as intoxicated as you thought, or tests come back, there is no head injury, and they want to go, fine. If the physician doesn't think that they should really go, but they insist, then they're going to sign the AMA forms and they're going to go, and there's nothing you can do about that. Yes?
I had an incident recently that the lab tech was too late coming to us to get blood from the patient, and the police wanted to know the blood alcohol level. And I said, I'm going to give you a simple rule, and he said that in the police department that there is apparently we could give the blood alcohol level result to them. But I said, well, I'm not sure, I never heard that.
So the police were telling you that the blood test we drew, we could give them the results of the blood alcohol level.
Often argue.
They ask all the time.
Yeah, detectives
come in at midnight sometimes to badger the charge nurse for this,
They come in to badger for the blood alcohol level. Okay. What excuse are they giving? I'm sorry, I shouldn't use the word excuse. What reasoning are they giving you for asking for the blood alcohol level?
They're not sure if the patient's really drunk, and so they want to know if they need to call and text and tell them they're all what.
they're on call.
Oh, God. Here we go. Here are the gray areas. But they have not arrested that patient, have they? So that patient is not under arrest. And if that patient is not under arrest and is not in custody, you don't need to give them any information whatsoever. Now, if the officer would like to arrest the patient and officially take that patient into custody, then you can give them the information. If they say we need to have a tech come in and draw blood, here's our probable cause, then fine. But, pardon me? Pardon me?
Provide the form for the chart that they are withdrawing blood by the lab tech.
Yes, I still want to see a form. Even if their lab tech is coming in, I still want to see a form. Yes.
So when you say arrest, they're under suspicion of a DUI. The officer is keeping their driver's license. I mean, I don't know what exactly under arrest is. You can get a DUI without ever having a blood test. They can be under suspicion of alcohol. So is that the case where?
You're not
necessarily under arrest, but you're under suspicion of DUI, and they're keeping your driver's license, and
they're keeping
basically for a DUI. They take your driver's license. They get a ticket even without, So is that considered under?
Now, if they're refusing a blood test, I can see where they could get a ticket, but this is something that we're going to have to try to clarify if we can. But if they're under suspicion, that's all it is, suspicion. That's not arrest. They have not been formally arrested. Yes. Yes, they can, yes. If they say the person is under suspicion, then you can respond, well then, okay, bring your if you have probable cause to believe, then go ahead and bring your tech in and do a blood draw. But unless that patient is under arrest, it's a violation of HIPAA for us to give out medical information, and the results of that blood draw that we took would be that patient's medical information. Okay? Now, go get a warrant and we'll give you the information.
One more question, because this happened once. There were 2 traumas going on. The officer was involved with one to get an accident report, and the other one, the tech was going through the belongings, found a kilo of marijuana. So it wasn't involved with the incident that he was reviewing. So does he get to make an arrest just because of the plain view that he saw?
Yes.
Okay.
Yes.
Okay.
If you are dealing with a patient's belongings and you find contraband, and I would report it, because if you don't, I would call our security and I would chart that you found that contraband and who you called and who you handed it off to. Okay? And I would keep it in your possession, or I would lock it up somewhere until you hand it over. Because if a patient comes back later and says, hey man, I had, whatever, dummy, why are you admitting that? But, you know, they're going to come after you saying, I swear I had, or, you know, let's get really far-fetched, worst case scenario, and say, you know, this is somebody working for the cops who got hurt and had something on them that the police knew they had on them, and it disappears somewhere. Who do you think they're going to look for? The people who cut clothes away and dealt with belongings. So if you find something like that, yes, report it to our security. Don't let it out of your sight. If it does have to be out of your sight, make sure it's under lock and key until you, the person who found it, hands it off to the next person. Okay? Think about it as chain of custody. You want to know where that went, where it got handed off to, so that you and chart it, so that you can say later, I was not the last person who had that. Yes.
I had a police waiting by the bedside wanting information as far as what injuries. Is he allowed to be there, or is he allowed to have that kind of information?
If the police officer is waiting by the bedside wanting to know what the injuries are, this is going to be another gray area. Don't you love them? If the patient is a victim and the victim is not able to respond, then yes, you can give the officer the information regarding the injuries. If the patient is a suspect and the officer tells you that this is an ongoing investigation, that they have probable cause to believe X, Y, or Z, and the patient cannot speak for themselves, then you probably can give them the information. If you are not comfortable doing so, if you are concerned that it is a HIPAA violation because you are giving medical information without the patient's consent, then don't do it and call risk management. Okay? Yes?
We just want to clarify, so if they're under arrest, we do whatever they ask us to do.
Yes, if they are
We
under...
don't need a form, draw blood if they're under arrest.
No, I still want a form.
Still want a form. Now, we've been told before, you know, like if you clean the site with, the reason they do it is because, like if we clean it with alcohol, they can say, ask us how we do it, all that kind of stuff. So do
Yes.
we need to know a certain procedure, or... I mean, can we just say, just call your tech, or is that...
You know, I would. Years ago, we used to have to go to court.
That's what I was
the
asking. Are we
reason
gonna end up in
you
court
call
if
the
we do
techs
this?
in.
Yeah.
I mean, that's why we started using betadine swabs. But you'd get stuck in court for hours because they were waiting for you to testify. That's why you tell them to call the techs in.
Yes.
There's on-call
So
text.
we really should not still be drawing blood from them and telling them to call.
If it's your policy to call the tech, call them. But if you, no pun intended, if you get stuck doing the blood draw, then, but sometimes you're going to do a blood draw when the police have not asked, just as a regular part of your job. The police may come in later and you've already drawn blood for something. And yes, you could end up in court.
Because we're going to send a BAL anyway. So why
Yes.
would we draw a separate one for them if we're doing it anyway? You know what I mean?
Yes.
Like it's already, our facility's already doing one. So if they can't do their own, they can just clean that information.
If they can't do their own and we've already done one, then they can get a warrant. If that person is not under arrest, they can get a warrant for those results. Yes. Yes, if you know they are under arrest, if the police tell you they are under arrest, they are in the custody of the police, then you can give them that information. Now, I'm sure you probably know why the police won't always arrest right away. Yes, money, money, money. Because if they're under arrest, the county has to pay for their hospital bill. And that is why they will quite often say, hey, give us a ring when they're ready to be discharged, because they are going to be waiting outside for them to arrest them after they're discharged. That way, they don't have to pay the bill. But they can't have it both ways. They seem to think that they can wait to arrest so they don't have to pay the hospital bill, but that we're going to give them all the information they need because they are the police. No, it doesn't work that way. If they're not under arrest, they have to go get a warrant.
Yes, I'm just going to make a comment. Sometimes they just need to know life-threatening, yes or no, so that they can block off the scene or something. Those rare patients come in.
Like your slide said, general injury information or something was okay.
Yes. General information like that, yes. If they want to know, is this life-threatening, you can say yes. I mean, you're under an emergent situation. The fact that the police are there and this person has a life-threatening injury, for me, screams probable cause. Okay? Whether it's the victim or a suspect. It doesn't matter at that point. It's just a patient to you. That person is just a patient, and if they want to know life-threatening or not, you can say yes or no. Okay?
I think we have to have AnnMarie back because this is all very interesting. And we all have tons of questions. We probably could have spent the majority of the day on this. So AnnMarie, thank you very much. We hope your face becomes more familiar to us for good reasons and not bad reasons. And thank you. The idea of an instruction manual would be awesome. It would be nice to have that resource.